Hello everyone, this is Shiv Prem, a legal intern at LEXIS and Company and currently pursuing BLLB honors from Central University of South Bihar. In this today's session, I will be dealing with the topic Judicial Review. So let us start this video. Judicial Review is a center in dealing with the malignancy in the exercise of administrative power. Law dealing with judicial review of administrative action is largely judge-induced and judge-led. The whole law of judicial review has been developed by the judges on a case-to-case basis. The present trend of judicial decisions is to widen the scope of judicial review of administrative actions and to restrict the immunity from judicial review of classes of cases which relate to development, deployment of troops and entering into international treaties and etc. Judicial review empowers the judiciary to strike down any action which is in any conflict with the Constitution. In the Constitution of India, the principle lies under Article 30. The article provides that the law to be made should be in line with the norms laid down in the Constitution of India, so that any existing law inconsistent with it is void to the extent of inconsistency. Thus, this gives power of judicial review to the judiciary. Article 32 and Article 226 provide the enforcement of the fundamental rights envisaged in the Part 3 of the Constitution of India. The power of judicial review is one of the basic features of the Constitution. In the Keshav Nanda Bharti case, it was explained very nicely. And in the case of Indira Nehru Gandhi versus Raj Narayan, it was explained there also. So now let us see some allied principles of judicial review. So the first one is principle of comity. If the organs of the state do not function in a spirit of mutually and coordination, public good cannot be served in any constitutional democracy. This principle requires that all the authorities of the state must supply the functions of each other necessary to enable authorities to discharge their functions in a responsible manner as per the norms and the values of the Constitution. Further, there is a principle of subsidiarity. Yeah, this principle signifies that the public functions and powers must be exercised at the level where it can be undertaken more appropriately in the responsible manner. For the exercise of the power of the judicial review, it may be a principle of judicial self-restraint and justicability. Political questions can be better decided by the political branches of the state. All policy matters can be better decided by the legislative branch of the state. Matters judicial in the nature can be better decided by the judiciary. Now, further, there is the principle of contextuality. In law, context is everything. Is the most fundamental principle of the administrative law. The validity of administrative action should be judged against the backdrop of the context, which may include the nature of the authority to which powers have been delegated. If the administrative authority is representative and responsible body, it can be trusted for the exercise of the discretionary power and put in such a way that it may not strict scrutiny tests. Further, nature and extent of power exercised, then procedure and processes of which administrative authority follows, and then express and implied limits within which the authority is executive powers. Further, there is principle of proportionality. It is a civil law doctrine which is now creeping into the common law jurisdiction, replacing Westbury doctrine of unreasonableness. In the application of the doctrine, the court examines whether the burden imposed by law is too burdensome to be disappropriate. Court has the right to exercise the power of judicial review to examine whether there is a proportion or balance between the limitations on the right and the illegitimate and sought to be achieved. Further, the Supreme Court of India used the power of judicial review from the time to time to uphold the values of the incorporated in the Constitution. So let us see some judicial review. The first one is judicial review of administrative action. The famous Westbury case, Associated Provisional Picture Limited versus Westbury Corporation, 1947, explains the meaning of the word reasonableness. It is true that discretion must be exercised reasonably. A person entrusted with a discretion must, so to speak, direct himself properly in law. He must call his own attention to the matter, which he is bound to consider. He must exclude from his consideration matters which are irrelevant to what he has to consider. If he does not obey those rules, he may truly be said and often is said to be actually and acting unreasonably. Further, there is a judicial review of policy decisions. In the case of Aruna Roy versus Union of India, the court held that it is for the parliament to take decisions on a national education policy one way or the other. The court cannot take a decision on the good or bad points of the education policy. Court can intervene in the implementation of the policy only if it is against any statute of the constitution. Further, there was a case judicial review of subordinate legislation. In the case of the state of Tamil Nadu versus P. Krishnamurthy, the Supreme Court observed that the state cannot make a rule to terminate private acquiring in sand without notice and hearing because the Enabling Act provides for it. Thus, the court held under the Rule 38 Clause A, framed by the state under the Mines and Minerals Development and Regulations Act 1957, as violative of the procedure provided under the Enabling Act. A subordinate legislation can be challenged on the following grounds, like lack of legislative competence to make the subordinate legislation. Further, the violation of fundamental rights guaranteed under the Constitution of India, then violations of any provision of the Constitution of India, repugnancy of the laws of the land, that is in enactment, then after failure to conform to the statute under which it is made in exceeding the limits of authority conferred by the Enabling Act. Then there was judicial review in the contractual cases. In the case of Tata Cellular versus Union of India, in this case, the Supreme Court observed that the judicial review is concerned with reviewing not the merits of the decision but the decision making process itself. It is thus different from an appeal. While hearing an appeal, the court is concerned with the merits of the decision, but in the judicial review, the court is basically concerned with the decision making process because the court is hardly equipped to review the merits of the decision. That's all for now. Let us meet in the next session with a different topic. And please do like and subscribe to the channel. Thank you.